This is a curiosity question for the two attorneys, or all of you. There's a icon or information piece in the upper left-hand corner of my screen that says we're live on YouTube. Does that appear on your screens?
Yes.
It does, Judge.
Okay. Interesting. I didn't know that before. All right, we're back on the record in cause number 26,650 for the case styled in the interest of Miles Robert Barbee, a child. The record will reflect that this remote video teleconferencing hearing for this remote video teleconferencing hearing, all parties and all attorneys participating in this case, as it was called before we took the recess, are back in the virtual hearing room. And the court has been advised that the parties have reached a resolution, an agreed resolution that they desire to present to the court. Let me take the first step of that and say it's my understanding that the parties stipulate to the establishment of the parent-child relationship for Mr. Allen, that he is in fact the father of the child, the subject of this suit. Is that in fact the stipulation of the parties? Mr. Maxwell?
Petitioner does so stipulate to that, Your Honor.
Mr. Stakely?
We do so stipulate, Your Honor.
Ms. Crump, is that acceptable to the Attorney General's office?
Yes, Your Honor.
All right, stipulation received. Now then, who's going to present?
I will, Your Honor.
All right, go ahead.
Your Honor, at this time, we would call Blake Barbee. It's Caitlin Blake Barbee in the pleading, Your Honor.
All right, Ms. Barbee, would you raise your right hand and be sworn as a witness? Do you solemnly swear that the testimony you may give in this cause shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may lower your hand. Mr. Maxwell, you may proceed.
Thank you, Your Honor. You are Caitlin Blake Barbee, is that correct, ma'am?
Yes, sir.
And Ms. Barbee, you have filed this petition seeking to adjudicate parentage and to terminate parent-child relationship between Miles Robert Barbee and Mr. Loomis Aaron Lee Allen. Is that correct?
Yes, sir.
Now, Miles was born on December 7th, 2018. Is that right?
Yes, sir.
And you and Mr. Allen have, through your attorneys, entered into certain agreements regarding termination of the parent-child relationship. Is that correct?
Yes, sir.
All right. Mr. Allen signed a affidavit of relinquishment of parental rights back on January 23rd, I believe, 2020. Let me make sure that's correct. Yeah, January 23rd, 2020. Is that correct?
Yes, sir.
Now, you understand, ma'am, that you don't have to agree to terminate his parental rights. You do understand that, correct?
Yes, sir.
You understand that you can move forward, establish his parentage, which we've already done by the stipulation, and you can request that he be ordered to pay child support, conservatorship be set up, and any possession and access provisions. You're aware of that?
Yes, sir.
All right. Part of the agreement he reached today regarding child support is that Mr. Allen be responsible to pay you retroactive child support. Is that correct?
Yes, sir.
And the amount that y'all have agreed upon is $10,000 payable on or before 2 weeks from today's date.
Yes, sir.
That's your understanding?
Yes, sir.
Now, if the court approves this agreement or approves the agreement and orders that Mr. Allen's parental rights be terminated, you understand that that termination is for all times, man.
Yes, sir.
After 30 days are up, you can do nothing to reverse that, rescind it, that you will forever be the parent raising this child and supporting this child.
Yes, sir.
You understand? And you understand this child will not have, Mr. Allen will have no right to see the child, be involved in the child's life in any way, shape, or form.
Yes, sir.
But also you will not have any right to try to obtain any support, further support from Mr. Allen, other than what's being paid in this case.
Yes, sir.
Has Mr. Allen had any relationship with the child up to now?
No, sir.
Mr. Allen's made it clear that this is something he desires, both in words, text, phone calls, and by execution of this affidavit of relinquishment.
Yes, sir.
And so I guess the question now is this something that you desire?
Yes, sir. Wholeheartedly.
And do you believe that it would be in the best interest of your child to go ahead and sever that relationship now, while he's still young and not knowing about Mr. Allen, and for purposes of his emotional welfare?
Yes, sir.
You ask that the court appoints you, of course, managing the service of the child. You have requested, and I'm assuming this will be no problem, that we get a medical history report from Mr. Allen.
Yes.
And I'm assuming, Mr. Staker, that will not be a problem.
That's correct. That'll be no problem.
And lastly, Ms. Barbee, you were asking, well, before that question, with regard to the $10,000, as I said, that will be payable within 2 weeks from now, which would be the 26th of January. Is that correct?
Yes.
And that is child support, correct, that you and he have agreed upon, retroactive
Yes.
child support. And so that would eliminate any claim that you have with regard to child support for years from birth until now. Do you understand that?
Yes, sir.
Are you asking the court to approve this agreement and order the termination in accordance with the agreement,
Yes, sir.
and order that the child support be paid by January 26, 2021?
Yes, sir.
All right, pass the witness, Your Honor.
No questions, Your Honor.
No questions for the witness, Your Honor.
Mr.
That's
Crump,
all
do
I
you have
have
any
this
questions?
witness, Your Honor.
Hold on, Mr. Crump, do you have any questions?
No, Your Honor.
Mr. Maxwell, what'd you say?
We would rest with this witness, Your Honor.
All right. Mr. Stakely, do you have any witnesses you wish to call?
Yes, we'd call Mr. Allen Aaron Allen to the stand, Your Honor.
Mr. Allen, would you raise your right hand and be sworn? You
Yes, sir.
solemnly swear that the testimony you may give in this cause shall be the truth, the whole truth, and nothing but the truth. So help you God.
I do, sir.
Thank you. You may proceed.
Thank you. Please tell us your name.
Loomis Aaron Lee Allen.
And are you the other party involved in this matter before Judge Armstrong?
Yes, I am.
All right. And as we have indicated, we have stipulated and had a test. You are the biological father of the child involved. Is that correct?
Yes, sir.
You've heard the testimony of Ms. Barbee with regard to the agreement we've made. Is that your agreement?
Yes, sir.
And do you, under the circumstances, believe that it is in the best interest of this little boy?
Yes, sir.
Right. And in that regard, you have in the past made some efforts to see the boy, but your circumstances have not permitted that, and frankly won't permit it in the future either, will they?
Yes, sir.
Do you ask, as we do, we ask the court to approve this so that we can go on with the rest of our lives and the boy can go on with the rest of his life?
Yes, sir.
Thank you, Judge. That's all I have.
Mr. McGee, you have any questions?
No, Your Honor.
Ms. Crum, do you have any questions?
No, Your Honor.
All right. Any further questions, Mr. Stakely?
No, Your Honor.
Mr. McGee, do you have any witnesses you wish to produce?
I have no evidence to offer, Your Honor.
All right. Ms. Crump, does the AG's office have anything to present at this time?
No, Your Honor.
All right. I accept the agreements of the parties as presented and stated in the evidence of the evidentiary testimony of the parties. I established the parent-child relationship between the child and Mr. Allen. I appoint Ms. Barbee as the managing conservator of the child, and whether that should be sole or just managing conservators, I don't think it really matters a whole lot. Because I further grant the petition based upon the affidavit of relinquishment. I'm getting ahead of myself. Mr. McGee, do you have anything that you wish to present as ad litem other than what you have previously presented?
Nothing in addition, Your Honor. I would just state that I believe the agreement between the parties is in the child's best interest.
That's where I was getting when it dawned on me I needed to check with the ad litem as well. All right. I further grant the petition to terminate the parent-child relationship between the child and respondent Loomis Aaron Lee Allen based upon the affidavit of relinquishment that has been filed, and further finding that it is in the best interest of the child to do so. I believe that takes care of everything that I'm called upon to determine. Anything else from any of the parties?
Yes, Your Honor, there is a matter of the ad litem in this case that has not been discussed. The ad litem fees, probably something Mr. Stakely and I need to discuss as well, but hopefully we can do that off the record. If we need the court's intervention on that issue, then we can contact the court in that regard.
All right. That's exactly what I was going to suggest. It bothers me a good bit to let the record seem to show that I agree with counsel, but I think that the parties can handle that themselves. If not, before the order is presented, let me know and I will dispose of that issue. But I think it's better, in my opinion, if the parties can do it by agreement. If you can't, I will rule. All right, anything else?
Nothing for the petitioner, Your Honor.
No, Your Honor.
No, Your
No,
Honor.
Your Honor.
Then we will be in recess. Let me ask the attorneys to stay on for just a moment. I have an academic question that really doesn't, it comes up from the facts of this case, but it really doesn't involve this case. Do either of the attorneys need your clients to visit with you other than through this mechanism right now?
No,
I do.
Your Honor, I just
All
tell Blake to hold on a minute. When I get done, I'll be up there, okay?
Okay, I will, the Zoom expression is I will remove you from the hearing. Thank you for your participation and I wish you all well. Thank you.
Aaron, I'll call you in just a minute. Okay, get Aaron on the phone as soon as we get through this.
You want to take us off YouTube, Your Honor?
Yes, I do. Hold on. Although maybe there's an